You've reached the end of your medical malpractice trial. The jury has been told to start deliberating and now start to answer the questions on the verdict sheet. The answers to those questions will form your verdict. But during the course of their deliberations, the jury sends out a note to the judge. It says, "Judge, we would like a calculator." What does it mean if the jury asks for a calculator while they're deliberating? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you sued your doctor and the hospital staff where you were treated, claiming that they violated the basic standards of medical care. The hospital staff and the doctor turn around and say, "Hey, why are you suing us? We did nothing wrong. And if we did something wrong, so did you, Mr. Patient." And they say, "Listen, if we did something wrong, whatever we did didn't really cause or contribute to your injuries." And then they say, "Hey, listen, if we did something wrong, and you did something wrong as well, guess what? Your injuries really are not as bad as you claim them to be." So now you've got a clear dispute, right? You say they did something wrong, they said, "No, we didn't." Now, they refuse to negotiate. They refuse to settle. What does that mean for you? It means your case is going to go the distance. It means that it'll take 2 to 3 years for you to get to trial. And now, after all this hard-fought litigation, finally, your case gets to trial. And it's 2 entire weeks to put on all of your evidence, all the testimony, as well as all the defense's evidence and testimony. And now, after the attorneys have made closing arguments, the judge gives the jury the law as it applies in your case here in New York, and now they are told to start deliberating. Go back and start talking about this case. Start with the very first question, which is, was Dr. Jones negligent? Was he careless? Yes or no? Then they'll have to answer the second question. Was the next person careless? If the jury determines that at least one of those people whom you have sued was in fact careless and violated the standard of care, now they will go to the next question, which is, was his carelessness a cause of your injury? We call that proximate cause. What that really means is that there is a link, a connection between the doctor's wrongdoing and your injury. There must be a connection. So, was the doctor's negligence a proximate cause of your injury? If the answer is no, your case is done and over. But if they find that yes, one of the doctors whom you sued was careless and his carelessness was a cause of your injury, by the way, it doesn't have to be the cause, only has to be a cause. If they find yes, now they will go on to answer the next series of questions which focuses on damages. And what are damages? Well, it's the amount of financial compensation the jury is going to give you as a result of your injuries. And that's really all the harms and losses and suffering that you endured from the time of the event up until the time of trial, as well as from the time of trial into the foreseeable future. So now, here comes an interesting question. There are instances where a jury will come back and they have questions, and they want something clarified. Maybe it's a question about the law that the judge gave them, and so they'll write out a note to the judge, say, "Judge, could you please explain proximate cause again? Judge, could you please explain what professional negligence means?" And now the judge will bring the jury back into the courtroom, and now he will reread or try and re-explain that portion of whatever they're having trouble understanding. And that's pretty common. There are some instances where a jury will come back and say, "Hey, Judge, could we have one of the witnesses' testimony read back in its entirety?" Never mind the fact that that witness testified an entire day. Now, technically, it's possible that the jury could go ahead and have everything read back. And the court reporter is going to sit there for another entire day reading back question, answer, question, answer. And that is a possibility. But you will find that most judges will not allow that. Instead, they'll turn around and say, "You know what, jury, if you don't understand or don't remember something that he said, why don't you guys go back into the jury room and identify that specific section or that area that he was talking about that you would like clarified. Then I'll have the court reporter identify that part of the testimony, and I'll bring you back in and have the court reporter read that section of the testimony to you." So that's clearly possible. Now, let's go back to the title of this video. Can a jury turn around and ask the judge for a calculator? The answer is yes, they can. So now you're sitting in the courtroom waiting for the jury to reach their verdict. Your attorney is sitting there, the defense lawyer is sitting there, or he's out in the hallway. And now they have a question. Can we have a calculator? So the first thing that happens is the judge will call the attorneys up. He'll tell them to come in, and now he'll call them up to the bench, and he'll show them the note. "Counselors, I just received a note from the jury asking for a calculator." And now the attorneys are going to be shocked. They're going to look at each other. They're going to look at the judge. The judge is going to look at them. And he's going to say, well, anybody have any objection? Now, why would he say that? Because each attorney has the ability to comment on a request by the jury. And then the judge ultimately makes the decision about whether or not he will go ahead and grant that request. So now the judge is giving each attorney an opportunity to either say something in favor of or against this request for a calculator. I will tell you, at this point, it doesn't matter what the attorneys say. The judge, in all likelihood, is going to give the jury a calculator. Why? Because they asked for it. The jury is allowed to see all the exhibits. They're allowed to see all the testimony, all the evidence that was presented. And now, if they have questions about a certain document or a certain exhibit, they are allowed to see it as long as it was admitted into evidence. If it was used only for illustrative purposes, where a doctor was explaining something using a diagram, but that diagram was never admitted into evidence formally, then they cannot see that particular exhibit. However, medical records that have been admitted into evidence, other documents that have been admitted into evidence, anatomical models that are now admitted into evidence, the jury can see all of that. So now they want a calculator. And now, what's the first thing that's going through your mind? Why would they want a calculator? Maybe they want to calculate out damages. Maybe they want to calculate out your lost earnings. Maybe they want to figure out how much money you are to receive into the future by multiplying certain things. Maybe they want to divide a particular number. Maybe they can't reach a particular number and now they want to cut it in half or cut it in some other proportion. That's all a factor. And here's the bottom line reality. We don't know, the attorneys, the judge, the litigants, we don't know exactly why the jury wants the calculator. We don't know what questions or issues have arisen that prompted the jury to now ask for a calculator. Can we ask the jury why? The answer is no, we can't. We cannot get involved in their thought processes while they are deliberating. At the end, after they've reached their verdict, now the attorneys can go ahead and talk to the jury to find out a little bit of insight into what prompted them to ask for a calculator. But during the deliberation process, now we cannot ask why. Why do you need the calculator? The judge will not ask that question, nor are we permitted to ask that question. Instead, the judge only has to either grant it or deny it, nor does he have to give a reason. So when he turns to the attorneys and say, does anybody have a problem with me giving the jury a calculator? No matter what the attorneys say, the defense or the plaintiff's attorney, the judge is in all likelihood going to give the jury a calculator. Now, I'll tell you something else that's very interesting. When that happens, a lot of things are going through the attorneys' minds. Now they're asking themselves the same exact questions that I just posed to you. Why would they be asking? Have they now reached the damages portion? They're now trying to multiply out a certain amount of money? What are they trying to do with the calculator? That type of question from the jury may prompt both the plaintiff and the defense to come together to try and reach a settlement before the jury comes back with a verdict. You want to know why? It's because neither side knows what the jury is going to do. Neither side can form an educated decision, an educated guess about why they're asking for this calculator. And in an attempt to try and control the risk, both sides may come together and say, you know what? Why don't we start talking, try and start negotiating this case? Maybe we can settle this before the jury comes back with a verdict. And now that's a calculated decision that each side is going to make. One side may say yes, the other side may say no. Or both sides may say, listen, let's go ahead and try and start to negotiate before they reach a verdict. Because once the verdict comes down, those negotiations aren't going to help at all. So, why do I share this great information with you? I share it with you because this does come up from time to time. And now, when it comes up, you'll have a better understanding of what's going on and what is likely to happen at that particular moment. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're contemplating bringing a lawsuit and have not done so yet because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.